day one of hearing stream 7 dealing with energy and network utilities. This is the session in which we invite the officers to summarise in a factual manner the questions that we've put to the various parties in relation to further information for the right of reply and in relation to any directions we've given in relation to expert conferencing. So I'll hand over to Hamish Wesney to take us through that list, and there's an opportunity for the panel to scrutinise that list and to modify and add to it as fit. Thank you, Hamish.
Point one, it's a factual question you asked right at the start of the day in terms of who are the submitters and the submission points that provide scope for amendments to the energy rules. We were adding in, recommended to add in various overlays.
Yes.
So it's just, factual question.
So I think you gave a verbal answer to that one, was Forest and Bird.
But I just double checked and reference the submission points for you there. And then this question two is a series of sub points, but this is the conferencing with Meridian Energy and Genesis around upgrading. So I've captured the 3 options as I understood them that Chair you summarised, and I just know I haven't included the option of the relief sought by Meridian submission based on your comments around the panel's preliminary thinking on that.
Yes, although
would you like that included for completeness?
Yeah, for completeness. Yeah. The starting point of 2B will be standards. It'll be A plus these enabling standards.
So that's option A. Option 1 is the relief sought in the submission, and then option 2 is a variation of that with less enabling standards, but haven't defined what less enabling means.
Yes, but it's only covering wind.
Yeah, not the other.
The idea was that solar and hydro would be unchanged, and I think Ms. Foster indicated that that was her intention anyway. So, in other words, fully discretionary.
And then the third option, permitted activity for minor upgrading is defined in the operative plan. So
Yes, okay. Yeah, we did. Yeah. Yes, okay. For completeness, yes.
Fourth option, different activity status for upgrading.
Yes. And if that could give consideration as to what the would that be the final, would that be the entry and final position?
Correct.
Yes, they wouldn't default to anything else, would it?
No, unless we thought meet some metrics or standards.
Yes,
appropriate.
But we might talk about that at the end of this in relation to solar.
Okay.
Yep.
And then a sub question relating to all of the options to confirm whether the permitted activity standards or the metrics manage the full range of potential effects arising from the nature and scale of upgrading.
I think I gave an example of noise. It wasn't listed in under option A, and therefore wouldn't be captured in B necessarily, but may be subject to a district-wide rules already. I'm not too sure. So, yeah.
And then this might be covered by the and above in point B, that it's only for wind farms and only existing.
Still worth confirming that. Yes.
And then a related question came up to clarify whether the Rule 6 or the definition upgrading should be referring to repowering and or expansion. To I think there's a mixture of words being used throughout the day. So
right.
If we can record the terminology that should be used. And then Commissioner Plimmer's question to clarify what is existing or what is established or consented but unimplemented.
Highlight that with my name beside
it. Then
Oh, it's you, as per the question yet.
What does it mean? And then what terminology should be used in the rule then?
Yes. Yeah. Well, it's a difference between the what's the intention and what's the delivery. Yes.
So once we've worked that out, then what's the appropriate rules to
reflect
that? And then lastly, I think Ms Foster and I
Yes.
it verbally, but we'll record that for the record. So is that everything that was related to?
Would put that into a minute for conferencing?
That might be helpful, just given the significance of,
Yes.
of the questions.
Yes. I'll review that.
And then point 3, this is a copy and paste from the hearing 6 questions, which is what Ms Banji just spoke about. So it is literally a copy and paste. But in terms of, if you want to reread that, in terms of the context of energy.
Was there anything that Ms Banji raised that you thought went beyond what the purpose of the conferencing was dealing with?
So the previous questions were solely focused on the policies.
Yes, 4 and 6.
Ms Banji elaborated today on the rules, the relationship of the rules between the energy chapter and the ecosystem chapter, which wasn't part of the original conferencing.
Oh, yeah. Is there, that's okay, provided the scope
That's
in the submission on energy and network utilities. And I wouldn't want to artificially separate it if it prevented a good outcome. Where, to use my language earlier, the eco chapters did the heavy lifting and resolved the matter. And because the idea is that the overlays, the rules are the rules in energy and generally, and then the overlays apply. Yeah. But like the new Plymouth situation. But I hate to hear that the conferencing had got bogged down on that. I mean, so
the primary focus is the policies.
6, and we need to understand scope.
So, the last conferencing did with Ms Foster, Mr Shield for Regional Council. That was something which will be covered at the end. I'm trying to think of the topic now. So many topics going on. I think that's
One of them.
Yes.
We made sure that was the NPS freshwater for strategic direction.
Yes. Yes.
So we made sure there was scope with the recommendation we came up with. Point 4. What is the rule managing energy, battery energy storage systems within buildings? So that issue rose in interpretation today.
RX.
Yes.
In your question.
And then related question for battery storage system within and outside buildings, how is fire safety managed?
Yes.
Very good. Man.
And then also a question around aviation requirements for erecting wind monitoring masts. Councillor Bauer, in terms of will provide a response to that question. And then the last one is around the scope of the SWAG and associated submissions relating to the matters in Ms Creevy and SWAG's own evidence today. Just I've listed a few examples there just to make sure that the relief they are seeking in the hearing today is covered in the original submissions.
Yes. That going back to the original submissions, it was difficult for us to understand that, but I think it's important we hear that from you. What I was trying to, one thing that you might want to consider, depending on the scope question, is whether some district plans, and I don't think this district plan does it, have assessment matters aligned to discretionary activities. They're not matters of discretion, and they're not always limited to those assessment matters, but they're to helpful guidance. And I'm just wondering whether there might be a role for assessment matters for this matter. Bearing in mind it may not actually fit with the structure of the district plan in terms of other zones, other chapters. The other matter that you might want to give consideration to, and it's one that raised by Alistair. It was about given that this is an evolving issue and we're still to get some definitive Environment Court Is this something that might see I don't want to call it preliminary, but an initial position established in the proposed plan decisions and maybe revisited down the track via a variation or a plan change if needed, once further guidance is received through Environment Court decisions. Just maybe you just comment on the efficacy or otherwise of that idea process.
There's something in all of this we looked at, I think.
Yes. It's just the reason I've said that, Craig, is that we don't have a sort of a leading authority on this yet. And we need to make a decision based on best information available. And the information received today was very useful. But how we package that up, it's sort of covered a little bit by B, but it might be a matter of sort of sitting back and taking it all in once we've got some more authority.
Also argue that the fact that it's gone to the Environment Court shows the system is working.
Yeah. Yeah.
Yeah.
Or
Or not.
coal.
Yeah, I think the only thing, when you talk about, you look at the possibility of
Oopsie.
based on groundwater,
Sort that to get that there.
or possible chemicals. But I can't even put my swimming pool water into the groundwater system in Marston. It has to go. So
Yeah, well, that's a good point. That's another thing. Some of the matters are raised by SWAG are in a
Jurisdictional.
different jurisdiction. Perhaps if you just comment on that.
Yes.
So, yeah, well, yeah. But I guess what I'm getting at with C, and without giving too much away, the panel will remember where there's an issue in the district plan on a different chapter where we're going to suggest that the council consider this in a wider realm. So it might be, D might fall into that also. Okay. Yeah,
That's everything on energy.
Yeah, energy?
Aware.
No?
The utilities, so again, the mix of some fairly factual questions. So the first one, is there a disconnect between policy P4, where undergrounding is required, and the rules on where undergrounding is permitted or consented?
Yeah.
Disconnect. And then policy 4 as well, suggested wording on the functional and operational, whether it could be included.
Yes, remember, yes,
Functional or operational
Yeah,
need throughout.
Yeah, that's further down. That was a specific question that came up regarding.
So you've also got, I'm wondering about the question of required or encouraged.
yeah, that's something I'd like to explore further. And whether or not the wording is around the wrong way.
I think that's, was that on policy
it
3?
was Miss
I
McLeod.
don't have a and or, but
I didn't have a problem with the way it's written because.
no.
But
Eyes down.
Yeah, I'd like to
Back up to avoid that.
was the
Don't forget that we're being recorded, so when we've got lots of other conversations going on, it makes it hard for anyone.
Oh, okay, that's fine. Now, 3 is
Whether the word.
Yeah, practicable. I think it was Mr. Horn,
yes,
wanted it included in those A and F.
yes.
Considering that.
Yes, you'd included an F and he wanted it added to A, I think.
That was
I think-
deleting some other words and then putting practicable in.
Included it in D.
Yeah. I think his submission was that he wanted some words, we were wondering whether if we deleted the words and then put practicable, whether that would address his
This is energy or
query.
network.
you want a practical under O2 or something or other.
Submission.
Oh, yes, you'd added it in E and F, Eddie, and he'd also wanted it in A. But also he wanted to add the words function and operational, I think.
Into F.
Yes. in the same way that technological or operational constraints have been added into C. It was going to provide some maintenance.
Yeah.
Yes. We need to capture that in the direction to, in a minute, Hamish.
Then rule 6 and rule 15 around the footprint of a network utility building.
Yep.
And how that 20 square metres was derived and is it appropriate? Have further consideration to alternative sizes approaches for that. No recollection I can add here that both PowerCo and the telecommunications companies were going to provide some information to Mr. Treadway to then respond to.
That's right. Yes, we could record that. And also make number 3 subject to them a minute 2 and 3. Yes.
And then a specific question for Mr. Treadway in response to, I think it was Mr. Anderson's question around what's the difference in visual effects between 2 towers with a 20 metre maximum height compared to 1 tower with 2 users having an additional 5 metre height.
I guess it applies to all 3 scenarios. Residential 15, commercial 20.
Yeah.
And rural 30.
All zones.
35. Yep.
Yeah.
And then question 5 was the effect of replacing an existing structure with a new structure under rule 3, and should the definition of upgrade recognise replacement?
Yes. Yep. On the basis that the policies and rules do.
Refer to replacement. And then there's the general question that came up around, there's a recommendation to amend rule 14 around the and or.
Yep.
So the question was, should it be and or should it be or throughout the chapter?
It may be that you might, well, maybe that the recommendation to change to or might be the outlier.
Yep. So we'll just do an audit of the provisions and provide you advice on that one. Then give further consideration definition of a pole. Just trying to remember the context for that one.
Mr. Horn, was it Mr. Horn had the telcos, wasn't it?
Which
Yes, this was the one where it added a line at the end of the definition, or a new line. It's
Definition of pole. He was still,
yeah, but it was in his evidence.
paragraph, suggested amendment on page 6 of his evidence, which was paragraph 17.
Yeah.
And that was including structures supporting other network utilities such
Yeah.
as electricity lines.
Or other stuff. Yeah.
Yeah. So paragraph 17, page 6 is evidence.
So that's just Mr. Treadway. You are
Page 6.
Page 6.
Hamish.
oh, sorry, page 6.
See, my notes do work.
Transpower related point.
yes.
The introduction re the national grid.
Yes. To happen, but not in advance of the other conferencing.
Okay.
Yep. I think we said by the end of April for that. Or no later than the end of April. For a joint witness statement at least.
Specific question around policy 3, on the words whether it should be enabled or provided for in relation to new technologies.
Yes.
Mhm.
And then to review rule 9 and rule 16 regarding the reference to voltage and whether there should be one rule or
Yes.
rule 9 being that rule.
Yes.
Rule 15 and standard 2. I think it's the telecommunication
That was Mr. Horn.
and power code.
Mr. Anderson.
Anderson.
Yes.
Attempting so that, and including the NZTA comments around road corridors.
Yes. The feeling of the panel there is that rule could be counterproductive if it's followed to its ultimate end.
And then the addition of the word relevant to the standards and whether it should be replacing relevant standards with the
Sexual standards.
So I think Mr. Anderson for the telecommunications was going to do a first run.
We should record that, yes, because they didn't stand into wordsmith it and provide.
Yes, you.
And then lastly, the Enviro NZ just that she reiterated in her presentation today, which was in her evidence.
How deep do we go on that, considering the direction being given by central government at the moment? Especially around waste disposal, like food waste, it's completely off. How deep do we go? Are we anticipating that it could be reversed in the lifetime of this proposal?
Oh, rubbish collection, isn't it?
But she was talking specifically about building and food waste.
What she did concede was that if we added to the definition of infrastructure, district or regional resource recovery or waste disposal facilities, that wouldn't have any effect on the rules. It would have perhaps a policy uplift when considering new facilities or considering reverse sensitivity effects of other activities in proximity to these waste facilities. That's what I got from Ms. Rosser. So maybe testing that claim about the implications. What would be the impact here at both the rule and policy level?
So that was everything that we'd recorded down.
Okay. Anyone think of anything else that's missed?
And just to confirm the standard 3 weeks period from.
Yeah, if you think you need more, come back. It'll depend on how quickly you can do that conference. We get that, get those 2 minutes out to telcos and energy. The next 48 hours, that would be great.
Yeah.
Thank you, everyone. It's been a long day.
It is.
Oh, yes. Hopefully that saves, now, hang on. We need to do 2 things. We need to do a carrot here. One on the right, stand and do that. Lead us off, Robin.
Ia whakaarea te tapu, ia wātia te tiara. Kia te tuki whakataha ai. Kia te tuki whakataha ai. Haurenge huie tai ie.
Thank you, everybody. I declare the hearing adjourned and is closed.